Thank you, Laura, and I want to thank our tech support. We could not do these presentations without all of the administrative activities that go into putting on these conferences. So again, thank you to the team at TLPI and the Tribal Youth Resource Center. I am very happy to welcome you all here to the Wellness Enhancement Training. We are in this virtual environment, and I want to thank you all for your presence today. And I want to welcome our presenters, the Honorable Judge Lawrence King and Judge Charlene Jackson. And we do have their full bios in the resource materials for the session, so I would invite you to review all the materials that are in the virtual conference center. You can learn more about our presenters today, but I just want to share that both of these presenters have been a part of TLPI trainings and are here today to present their perspectives on confidentiality and ethics and the importance of that in both the juvenile healing to wellness court and the adult healing to wellness court. And so we're very happy to have them in the juvenile track today, sharing more about their work in tribal communities and their perspectives on confidentiality and ethics. So with that, I'm going to hand it over to Judge King and Judge Jackson and thank them again for their presence and their contributions to this meeting.
Good morning, everyone. My name is Judge Jackson. I am an attorney here in the Phoenix metro area with the solo practice. However, with my solo practice, I'm also a judge for several tribal courts in their appellate system and a pro tem for other tribal courts and a judge for 2 municipalities. And my experience with the Healing to Wellness Court is based on my time as the chief judge at Fort McDowell Yavapai Nation and with my consultant work with both TLPI and NADCP. I'm happy to be here, and I will allow Judge King to introduce himself.
Hi, my name is Judge King. I am currently the Chief Judge of the Morongo Band of Mission Indians Tribal Court. My experience with healing the wellness courts comes from Judge Jackson when I worked for her at Fort McDowell Yavapai Nation Tribal Court, and the stuff that we've done at the Colorado River Indian Tribes through our community court. And so with that being said, I'm going to let Judge Jackson do what she needs to do, and then I'm going to step off and come back on.
Thank you, Judge King. Can we advance the slide, please? Well, what kind of attorney would I be if I didn't start with some type of disclaimer? So here we go. This presentation is brought to us by a grant from the Bureau of Justice Assistance. And it should be noted that while they were generous enough to bring us this presentation or allow us to do the presentation, any points of view or opinions in this document are those of Judge King and I. They don't necessarily represent the official position or policies of the Department of Justice. I also have to add that this presentation should not be taken as legal advice. It is for educational purposes only and is not intended to create an attorney-client relationship between myself or any of your organizations or any of you individually. Again, it's for general educational information. If there's a situation where you are questioning something that's going on in your Healing to Wellness Court specifically, I invite you or suggest that you reach out to your own legal counsel to advise on specific circumstances. Now that we've proceeded with that legal disclaimer, we will get into the meat of the presentation. So if we could advance the slide, thank you. So here we go. The first question is always why? Why are we doing this? What is the point? How does this help us? And where do we go from here? Well, there's a lot of people seeking help, whether it be legal help or medical help, and there's lots of TV shows based on medical interventions. And so usually it's because something happened. People are found in a situation where they need some type of help. And again, whether it be legally, mentally, medically, but sometimes those things are of their own doing, and sometimes they're the victims, or they just happen to be in the wrong place at the wrong time. And some of those situations can put individuals in embarrassing situations where they don't necessarily want to tell the full story about what happened. But sometimes that full story is necessary in order to get them the help that they need. That is why we have confidentiality rules. in the treatment arena, we want to be able to provide those individuals that come to treatment the ability to deal with their addiction minus the stigma. The rules with regard to confidentiality for medical and treatment purposes, they're designed to encourage those experiencing substance use disorders the ability to obtain treatment and remain in treatment long term, to be open and honest with their treating professionals, and to know that their information that they're sharing is protected. We all know that open and honesty are a tenet of the Healing to Wellness Court. And so the confidentiality rules do assist in that arena. So if we could advance the slide, please. I am here to assure you that the goals of Healing to Wellness Courts and Juvenile Healing to Wellness Courts and the confidentiality laws are compatible. And I'm sure that someone's going to be in the background saying, how can that be? We all need to have all this information to address the individual's needs, but yet we can't always get all that information. So how are these laws compatible? Well, both are designed to help substance abusers overcome alcohol and other substance use issues. But in addition to that, there is a limit to the information needed to properly treat and help an individual. And I mean needed by the team as a whole. Some of the individuals on the team may need more information, some may need less. And this is where the mutual trust and respect for each member of the team comes into play. It requires an acceptance and understanding that there are certain professionals on the team that may get more information, and that the legal requirements of their positions may prohibit them from sharing the full extent of information. But it also requires us to understand that, accept that, and to be professional about it. So that is why we want to talk about these requirements, so that everyone has a mutual understanding and respect of what is required to be shared and how you can share information and the limits of that sharing of information, which is the tenet of the entire presentation. So if we can advance the slide. What laws are we talking about? Now, whenever I give this presentation on confidentiality, HIPAA, 42 CFR, I always call it the Chicken Little presentation. And I call it that because this is the excuse or the justification that is constantly given by people to refuse to share information, because there's a general fear of sharing that information and maybe getting in trouble, whether it be by the behavioral health licensing agency or by some other mechanism. And if you recall, anytime you go to the doctor, you're required to sign the HIPAA form, the release of information form. And all of that is generated by confidentiality laws. And there are a couple of them. First is the 42 CFR or USC confidentiality law. And then there's 42 CFR Part 2. And then there's HIPAA, the Health Insurance Portability and Accountability Act, or the Privacy Rule as it's referred to. And then there's the Family Educational Rights and Privacy Act, or FERPA. All of these apply to situations where you might find yourself in as a provider or as part of a Healing to Wellness court. And it is important that we have a respectful understanding of what these laws mean and what they say, so that we can confidently share information as appropriate and as needed, to the extent needed, for purposes of providing quality services to our participants. So you may advance the slide. What is confidential information are we talking about? What are we really referring to? Well, in the Healing to Wellness Court sense, whether it's an adult or juvenile or even family Healing to Wellness Court, we're talking about a person's substance abuse history. And that history is, we have to understand, is federally protected. And the point of that protection is to encourage those needing treatment to seek help without fear of repercussions. If you think about some of our individuals, they may have a job or they may have been terminated from a job, but one of the things that they may be afraid of is that they may not be eligible for another job if this information comes out. So the confidentiality is needed to give them the ability, as stated previously, to seek that information or to seek that help without fear of stigma or repercussion. Right, you may advance the slide. So let's get into specifically HIPAA. I'm going to address HIPAA, and then I'm going to turn it over to Judge King, and he's going to talk a little bit about the other confidentiality laws. But let's talk about HIPAA first. It's kind of funny because the original goal of HIPAA was to permit the transfer of medical information electronically when someone changed jobs. When you change jobs, sometimes you change insurance carriers, and that information, your medical information, is needed to make sure that you're eligible for coverage, or what coverage is available to you, or to make sure that there's a continuation of care. It was one of the tasks was to save the environment and move from the transfer of bulky paper files to electronic transmission. However, they did recognize that when you're transferring something electronically, sometimes you lose custody and control of where it might be, whether it be it's sent to a wrong email address or it's intercepted inappropriately. And so the laws were enacted to try to protect some of that information and to place the onus on the holder of that information to make sure it's safe and secure. However, it has become one of the big excuses for not sharing information. However, you also need to know that there are repercussions if information is shared, and likewise, there may be repercussions if a request for information and an authorization for information is not shared. What does HIPAA apply to? It applies to covered entities. And if you look at covered entities, that's in quotation marks for a reason. Anytime you have a lawyer give a presentation and they have covered entities in quotes, or maybe bolded or capitalized, that tells you that there's a specific definition in the statute. Well, in this case, covered entities include health plans, healthcare clearinghouses, billing services, community health information systems, and healthcare providers. So it specifically applies to those groups of people. Wellness court is not included in that list, and it may not be considered a covered entity at this point, but the treatment provider, who is an essential part of your team, is a covered provider. And that's where the rub comes in, because the treatment provider is receiving all of this information, right? And that information is relevant to treatment and relevant to making sure your participant is getting the services they need. But the treatment provider sometimes is not able to share that information or all that information. And this is where the trust aspect comes in. Your treatment providers need to know that they can trust you with information they're allowed to share, or information that they have consent to share. And you also need to know that you don't get all the information. You don't need to know all the information. And you also need to be able to trust your treatment provider is providing the quality services that your wellness court wants to provide. It's challenging because we have a natural desire to know information. We're curious. We want to help. We feel like the more information we have, the better off we are, the more resources we can have. But at the same time, we have to have a healthy respect that the treatment provider may not be able to provide all those details. And we also have to have a healthy respect that we don't necessarily need to know all the details involved in treatment. So let's move on. Next slide, please. Why do we care? Why do we care about HIPAA? Well, first of all of our treatment providers are subject to it. They're subject to the requirements, and these providers are the main stewards of the protected health information that we want access to. That's what we think we need to have in order to provide quality services to our participants. However, as I mentioned previously, it's important for us to realize, recognize, and respect that providers can only provide or only release protected health information in accordance to the HIPAA privacy rule. There are requirements that they have to comply with, or their license could be subject to sanction. On the flip side, if that consent is provided, and we'll talk in greater detail about consent a little later on in the presentation. On the flip side, if that consent is provided and it meets certain qualifications, the treatment provider can't withhold that information because the owner of the information is the participant. It's also important to note that HIPAA and the Confidentiality Law, Part 2, they generally parallel each other. There are some minor differences, but they do provide much of the same protections and much of the same information. So let's move on. What are the definitions? Anytime you're looking at laws, you will be interested to know that some of the terminology or words put together in the law have a specific meaning for that law. Well, in terms of HIPAA, specifically, we are talking about protected health information. Well, what is that? Is that everything? Is that certain documents? What is it? Well, under the HIPAA, protected health information is individually identifiable health information that is created or received by the healthcare provider. So that's information shared with from the participant to the healthcare provider, or maybe the doctor's notes or the therapist's notes, the treatment plan or the health plan, the employer, the healthcare clearinghouse, and that relates to the past, present, or future physical or mental health condition of an individual. It also is information that relates to the provision of healthcare to that individual, as well as the past, present, or future payment for the provision of healthcare to an individual. So that's a lot of information, but at the same time, it gives a general guidance of what is covered. Okay, let's move on. When talking about releasing that information, it's important to know when a patient's authorization is required. And it's also important to know that authorizations are governed by both state and federal law. And as I mentioned prior, it's critically important that you understand that the information belongs to a patient, not the treatment provider. And there are only certain circumstances when the treatment provider can say that they can't release the information. We'll get to that later. But it's also important to know, as I stated, that because the information belongs to the individual, they can authorize the release. And if the release isn't executed, again, with the exception of those certain circumstances, that the treatment provider or the provider can face ramifications because they are only the holder or the gatekeeper for that information. The owner is the individual. With that, I will turn it over to Judge King and allow him to share about other confidentiality laws and regulations.
Thank you, Judge Jackson. Let's go over part 2, CFR part 2. Next slide, please. Okay. So as previously said, this is the provision, the code of federal regulations that deals with substance use disorder individuals so that they do not get stigmatized going into programs. And as you can see, this covers any program or activity relating to substance abuse, education, prevention, training, rehabilitation, research, which is directly or indirectly assisted by any department or agency of the United States. And as you can tell, courts are included in this definition. By extension of logic, wellness courts that derive through regular tribal courts or state courts would be covered underneath this particular provision. Next slide, please. Okay. Little history. This was first issued in 1975. It was revised again in 1987. It's been revised again with some updates for 2020. And we'll talk about the CARES Act and what that did with Part 42 under the pandemic coming up. It was designed to help and deal with the stigma of addiction. Primarily requires notification of confidentiality, consent forms, and the prohibition of redisclosure, okay, which is very important. Redisclosure. So despite the fact that you may get some information, you can't redisclose it someplace else under this regulation. So essentially, and I don't know how many people that are participating may have heard this in their wellness team meetings. I'm sorry, but I can't acknowledge whether this person is or isn't in our treatment program. That's the gist of it. But there's some rules. So let's go to the next slide. It imposes restrictions, again, on the disclosure and use of patient records that are maintained in connection with the performance of any federally assisted alcohol and drug abuse program. And most programs get money from SAMHSA or the Department of Health Services, so therefore they would be covered. Next slide, please. Several rules apply to participants in healing courts. We have, again, Part 42 CFR Part 2, which is the Alcohol and Substance Abuse Treatment Confidentiality Rule, and then HIPAA, the federal rules covering all health-related information. Next slide, please. No covered information can be disclosed unless by consent of a participant or specifically authorized or as specifically authorized by Part 2. That's very important to remember. And as Judge Jackson said before, she's going to cover this consent when we go a little bit later. But there are some parts of Part 2 that will allow you to disclose information. Next slide, please. So let's go into the CARES Act. Okay. As everybody knows, we're in a pandemic, hence we're not next to each other in a room, probably in Albuquerque, New Mexico, someplace, getting ready to go have burritos or green chili someplace, okay, at a famous restaurant in Albuquerque. So we're doing this virtually. Because of the CARES Act, it did some alignment. So we look at HIPAA versus CFR Part 2. HIPAA is primarily healthcare industry. 42 CFR Part 2, drug and alcohol programs. You know, these laws covered a lot of the same materials, but there were some differences, okay? Some of the points of difference, more specific or more recent rules usually apply, and that's one of those legal concepts. So if Congress or agency comes up with something that's a little bit more restrictive, then we go from there. For treatment providers, in most cases, the rules of CFR Part 2 are a little bit more stringent going forward. Next slide, please. Okay. So through the CARES Act, it amended a couple of things, and it aligned Part 2 a little bit more with HIPAA regulations. One of the in the weeds part is Section 3221 of the CARES Act, which amended, Part 2's underlying statute and struck a balance. The amendments allowed for disclosures for treatment, payment, and healthcare operations as permitted by HIPAA regulations, but required an initial consent from the patient that could be revoked, okay? And that's very important that they have an opportunity to revoke those things. Notice privacy practices were included going forward, and you have to make sure that you deal with the breach requirements that were going forward as well. I've included a handout in the collateral material that was issued by Anna Macklin and Andrea Frey on April 1st, 2020 that goes into a little bit more detail, as well as a fact sheet from SAMHSA about the revised rules for part 2 on CFR 42. Next slide, please. Disclosure. Okay, next.
Judge King, I'll happily take this off of your hands.
Thank you.
Let's talk a little bit about disclosure. Well, how do you get the information? Wellness Court requires us to share information in order to properly treat the individual on a holistic basis. But how do you get the information when you have all of these rules applying to the treatment provider or the healthcare provider? How do we get the information so that we can do what we need to do? Well, in the law, we always have general rules. So the general rule of disclosure is that treatment programs may only release information or records that will directly or indirectly identify a drug court participant as a substance abuser or treatment patient with a knowing and written consent from the participant. And I emphasize the word knowing because a lot of times our participants aren't really 100% knowing when they come into the treatment program. And so one of the recommendations is that periodically you go back and you get that information or you get that consent on a continuous basis to make sure that when all the lights start really working in the brain, once the substances start clearing out, that they are fully aware of the information that they're sharing. But there's also court orders that can cover that in the event that we start getting some resistance. It needs to be in writing because we don't want to have a he said, she said situation. I mentioned that I was a pro tem at several courts, and I'm handling a case right now where it is involving an unwritten lease agreement. And let me tell you, that is a nasty case because it is a situation of he said, she said. And, it becomes very challenging to resolve that without the writing portion. But there are also 9 limited exceptions to the general rule of disclosure, and we'll discuss those here shortly. So let's move on, please. Okay, let's talk about the 9 exceptions for the non-disclosure rule. One is that you can share information that has no patient identifying information. If you can't tell who the patient is there really any harm in disclosing it? That's the question. You may argue yes or no, but generally speaking, if there's no way to disclose who the patient is, who their identity is, what their identity is, and who their identity is, you can disclose that information. You can also disclose, there's also an exception for the disclosure of internal communications. That is communications amongst the agency providers or the individuals involved in treatment. However, I am going to caution you that you do need to still be careful that you don't unknowingly share some patient identifying information when you're communicating either by email or text. So you really need to make sure that there is no patient identifying information in that, or a way to identify who the participant is in your communications. I'm going to caution you with that as well. The other exception to the non-disclosure rule is proper consent. The emphasis there is on proper consent. The consent has to meet certain qualifying terms or meet certain qualifiers in order for it to be considered proper. Another exception is the qualified service organization agreement. Now, what this is this is a two-way agreement between a Part 2 program, which means an agency that is subject to Part 2 rules, and an individual or entity providing a service to the Part 2 program. That might be a person providing billing or a company providing billing, data collection, staffing, or professional services. It is not the individual treatment services like case management. So in those instances, if there is a service agreement between the treatment provider or a Part 2 provider and a company providing some type of administrative service, that's an exception to the non-disclosure rule. However, it's important to note that the qualified service organization is, by entering that agreement, and within that agreement, there should be a provision that states that they are still covered by Part 2. So just because you release the information to ABC Billing Company doesn't mean ABC Billing Company can then disclose to a third party or someone else. In that qualified agreement, as I mentioned, there needs to be a provision that the service organization recognizes that they're bound by Part 2, and that when there's a judicial proceeding, that they will resist efforts to not disclose the identity of the individual regarding their substance abuse, diagnosis, or treatment. It's also important to recognize that the qualified service organization can do some redisclosures, but those are extremely limited. They can redisclose to a contracted agent helping the service organization provide services. So if there's a subcontractor, for example, providing billing services, they can do that. Let's say ABC Billing utilizes a contractor that works, one of the situations where the contractor works from home or is a private individual who just gives services now and then, they can release that information, but all those other rules still apply. And then the qualified service organization can release information back to the Part 2 organization for purposes of fulfilling their contractual obligations. So this is kind of an administrative exception to the non-disclosure rule that recognizes that there may be other companies or individuals involved in providing services. This is not generally your case management or not necessarily your wellness court, but it's worth mentioning so that people understand how that works. Another exception is crime on program premises or against program personnel anywhere. I should also point out that this particular non-disclosure exception might be qualified by applicable state law. For example, Arizona has like 6 or 8 different laws that must be disclosed in this situation. You can have an exception to non-disclosure for research and audit purposes. If your program's being audited, your provider would sign a confidentiality, and that would allow you, and the individual agrees, that would allow you to disclose that information for research and audit purposes. If the court orders disclosure, now there might be certain circumstances where an individual is reluctant or there's some concern, the court can order that disclosure of information. If there's a medical emergency, let's say that the participant is claiming to, be suicidal, you would want to be able to release that information to properly address that medical emergency. And of course, the reporting of suspected child abuse or neglect is an exception to the non-disclosure. And in fact, individuals may be required to disclose that as a matter of law. So let's move on. How do you obtain that consent? You want to obtain that consent and start talking about it when you first have contact with an individual, whether that be at intake, screening, or assessment. And you want to make sure that it's addressed every time you have contact with that individual. You want to make sure that they understand that while they're involved with the program, there will be the release of information, and you want to give them the opportunity to consent. Keeping in mind, again, that when you see them at intake, they may be under the influence. So you want to make sure that each time you have contact with them after that point, when the brain starts functioning a little better, minus the drugs or alcohol, that they are advised that the consent is there, that they've given consent, and then the consent is continuous, or that they will continue on. So you want to make sure that they understand that. So let's move on. Well, what has to be in the consent? You can't just have a general written statement that says, I release the following information. Under the law, there are specific things that must be in a consent form. First and foremost is the name of the person or organization that may make the disclosure. So it might be Healing to Wellness Court, it might be the specific treatment provider, and in some instances, you may want to do both. It has to include the name or the title of the person or the organization to whom disclosure may be made. Who is entitled to receive this information? It includes the participant's name or the person authorizing the consent, the purpose of the disclosure, what the information can be used for, how much and what kind of information may be disclosed. It's important that the consent have the signature of the participant or the participant's authorized guardian, the date on which the consent was signed, and the date, event, or condition upon which the consent will expire. Now, keep in mind, some states may require a specific duration, unrelated to treatment, but as an example, in Arizona, when you have a power of attorney over a child, it expires automatically in 6 months. So you can't just take power of attorney and it has, indefinite duration. It has an expiration date of 6 months, and those have to be renewed at that point in time. Similarly, you need to check your jurisdiction to see if there is a maximum duration applicable to this type of consent. And that's why the dates are important. That's why the events are important, or other conditions on which consent will expire. The date might be what's allowable by law. It might be 1 year. That's something that needs to be really discussed in your organization. It might be an event, maybe when they complete Healing to Wellness Court, whether it be satisfactorily completed by graduation or commencement, or whether they're excluded from the program by rule or whatever gets them eliminated from the program. Though that information needs to be considered and included. It's important to note, though, in most instances, consent cannot be revoked unless in a juvenile or family court setting, in which case the law requires it. That's important because you don't want an individual to simply get down the line in your Healing to Wellness Court or in a treatment program and then say, you know what, I changed my mind, you can't share information, as a way to manipulate the program. So keep that in mind as well. We can move on. So let's talk about that consent in a little more detail. A proper consent can authorize the parties involved in healing to wellness court or drug court to share the information necessary to monitor treatment and compliance. That doesn't mean, again, that you get all aspects of treatment. It just means you get the information that is necessary to monitor compliance with your program and whether or not the individual is making progress. There are aspects of treatment that need to remain in treatment. You also have to understand that even though proper consent is in place, disclosure is not mandated if the entity thinks information will harm the individual. This is also situational because that information belongs to the individual. In Arizona, several years back, we did have a treatment provider that was sanctioned by the Behavioral Health Board of Examiners because that individual did not release information, pertinent information, even though there was a consent in place. And what happened in that situation was that the treatment provider was sanctioned and was required to undergo corrective action in order to maintain their license. In that case, I'll just give you a couple of the details. The treatment provider was seeing an individual for suicidal ideation, depression, anxiety, and had expressed that they were suicidal. At the same time, the individual was seeing a medical provider, and that provider prescribed Ambien, which is a sleep medication. And one of the side effects of Ambien is suicidal ideation. However, the medical provider did not know that the individual had expressed suicidal ideation. And even though there was a release of information for those two agencies to communicate, that information was not shared. And in that instance, despite some claims that the information couldn't be shared by the therapist, the Board of Mental Health Examiners said this information belongs to the individual and it was critical for proper medical care. And because the individual agreed to share the information and directed you to share the information and authorized you to share the information, and it was for their medical benefit and protection, you should have shared the information. So here's your corrective action. So keep that in mind as you're moving forward, that there may be limits to the consent or how much information can be shared, but at the end of the day, the individual does hold that consent. So it's walking a fine line. Keep in mind also that unless a consent specifically permits, a program cannot disclose information to law enforcement seeking to prosecute for a separate crime. This is a question that consistently comes up in doing the foundational program development through NADCP, and then the on-site program operational tune-ups that I sometimes get to go on. This is a question that comes up frequently, is what if an individual discloses a crime in the course of their treatment? Do we, share that information? Can they be prosecuted? And this is addressed by a proper consent form, but it's also addressed by, some of the exceptions to the disclosure requirement. And it's also addressed by, or should be addressed by, your programmatic policies and procedures. I'll give you an example of how this came into play. And it wasn't specifically a healing to wellness court issue, but it was a case several times over cases I presided over, where the individual pled guilty to a crime. And before sentencing, we requested a pre-sentence report. And in that pre-sentence report, there was discussion about other crimes. And the prosecutor would frequently want that pre-sentence report for purposes of enhancing penalties, or in certain instances, trying to file another case that they were investigating. So you have to keep that in mind, that sometimes this disclosure of the information may be harmful to a participant, but you also have to keep in mind that you have to walk that fine line between what is in the public's best interest as well as the individual's best interest. So it's clear as mud, right? I'm just kidding. It can be hard to navigate that. Let's talk a little bit about minors. Next slide, please. All right. When you're dealing with minor participants or minors in general, you have to keep in mind that state law governs when parental consent is necessary for a minor to obtain treatment. The minor signature is required for disclosures, even when they're disclosing to parents. This becomes tricky, obviously, when you have a situation where the parent wants to be involved either because they really care, or the parent wants to be involved because they're really concerned that what's coming out of my kid's mouth that might look bad on me. Minors do have some autonomy in this situation, and you do need to obtain their consent. This also addresses the fact that you still have to have parental consent in some states that require parental consent for treatment. Please check your state law or the applicable law that applies to your program on how to best handle situations involving minors. Next slide, please. Requiring consents. So back to the original tenet of Healing to Wellness Core is it's a holistic approach at treating an individual that requires sharing of information, because we like to have what I call overlapping circles to the treatment as opposed to individual silos. And we also know that the holder of the information is the patient or the participant. So how do we address this when the participant may not be so willing to share as a way of maintaining their ability to continue to use? Well, HIPAA prohibits a program from conditioning treatment on a patient signing a consent. So in that instance, you would think, well, then the participant can just refuse to sign the consent form and then our hands are tied. However, a participant that's involved with the court and under the supervision of a judge, that HIPAA sharing, that sharing of information, or that HIPAA requirement can be addressed, because the judge or even probation or parole and child welfare can condition participation in the Healing to Wellness Court program on the defendant signing the consent form. So it comes across as a little coercive, but at the end of the day, participation in Healing to Wellness Court is somewhat voluntary, in that they can choose, an individual can choose to just go through the regular criminal justice system. So that is the avenue by which you address or handle the HIPAA prohibition requiring consent. Can we move on? So how do we satisfy these two seemingly big, scary confidentiality rules and laws that apply? Well, HIPAA requires all consents to be revocable, but again, HIPAA also allows for the use of an administrative order for information disclosure. Therefore, you can, and your program can pair the two, 42 CFR with HIPAA, with a HIPAA administrative order, and or build HIPAA language into the consent form to address the two individual laws and their requirements. Let's talk a little bit about consents in family court. I mentioned previously that in certain instances, the HIPAA consent needed to be revocable, and that's specific in the requirements of the law. There is no criminal justice exemption for the family court setting. That consent can be revocable, but if they revoke that consent for sharing of information, there are consequences, and the consequences, maybe they can no longer participate because you need that information sharing to properly handle their treatment. However, the consent in family court must be revocable, but as I said, if you have a program rule that deals with that, that participation is required, consent is required as far as participation goes. And if they want to revoke their consent, they can. However, there are ramifications for that. So make sure that your program covers that as well. With that, I will move on and I will defer to Judge King.
Okay, thank you. So when asked to do this presentation, one of the things that I realized, we all talk about Part 42, Part 2 CFR 42 Part 2. We also talk about HIPAA all the time, but especially in juvenile healing and wellness courts, especially in family courts, especially in this healing and wellness courts period, we have people that for some particular reason may have dropped out of school, or may have some issues, or may have an individual education plan that you should know if you're going to take a holistic approach going forward. And because of that, I said, well, where are we talking about, the Family Educational Rights and Privacy Act, so that when you try to get information from a school, they go forward. And they're not hiding behind things, and they don't say, I can't give something to you. So just a quick little note, if there's a raised hand down on the bottom, how many people that are currently on this have heard of the federal, this law, Family Education Rights and Privacy Act. If you just hit your raise hand button, that'll give us a number. All right, next slide, please. All right, so let's talk about this. This protects the privacy of students and their educational records, okay? So you just, if I'm running a juvenile healing and wellness court and I have a kid that has a substance use disorder, I'd like to know how they're doing in school, because that would be very, very important. I also would probably like to know what the school has done in trying to address some of the needs going forward, and seeing what happened. So this little note, I'm glad I'm going to be covering some information that people probably not gone over before. So FERPA applies to educational agencies and institutions that receive funds under any program administered by the Secretary of Education. Every school in this country gets money from the Department of Education, so therefore this is going to apply. And you say most private and parochial schools at the elementary and secondary levels do not receive funds. Yeah, that's good. However, that's a general rule, but I would bet that that's probably going to be changing, or it could be one of those ones where charter schools get pass-through funds, or private schools get pass-through funds through public education funds, because of that movement that we're doing of sharing funding for public education and school choice. Next slide, please. Laura, next, thank you. All right, so parents have rights under FERPA. You know, they have the right to inspect and review the educational records of their child. They have the right to seek to amend educational records. They also have the right to consent to the disclosure of information from educational records, except as provided by law. And so it's important when we're dealing with this, and when you set up your consent forms, that you put a part of uh, language in that consent form that deals with FERPA, especially if you have any kind of educational records that you're going to be looking at, an IEP, maybe a school psychiatrist records, et cetera, to be able to determine what kind of treatment or treatment plan is going to be necessary for the participant in the program. Can I have the next slide, please? Okay. Eligible students, their rights. When that person turns 18 or goes to post-secondary, any rights under FERPA, to the student, go with them. Okay, and that would be parental rights as well. So the ability to limit the amount of information that's being disclosed. Why it's very important to be able to have a consent portion of your consent form that deals with FERPA. Next slide, please. Okay, so let's talk about some definitions again. As Judge Jackson said previously, things that are in quotes typically have legal definitions and legal meanings. So here, educational records are records that are directly related to a student and maintained by an educational agency or institution, or by a party acting for an educational agency or an institution. Next slide, please. And let's go, I'm gonna go back one more slide before. Thank you. When you talk about institutions acting on behalf, that would probably cover the people that do the SATs or the ACTs, and hopefully our participants may be going forward, or third party compiling agencies. Next slide, thanks. Okay. It also includes records of students receiving services under Part B of the Individual with Disability Act, as their records are subject to FERPA. And that's where one would have to have an IEP, or not necessarily an IEP, an individual education plan, but there could be a program that's set up if a child is in a classroom setting that has a disability, to make sure that child has the ability to obtain an education through an adequate accommodation. Medical and or health records, such as education records, are subject to FERPA. Got to and that's within the record of the child. So any kind of health records that the child may have that's in their educational records are subject to FERPA. Next slide, please. There's some exceptions, okay? There's always exceptions. So records created and maintained by a law enforcement unit for law enforcement purposes is one. The medical and psychological treatment of those records of an eligible student, if they are made, maintained, and used only in connection with the treatment of that student and disclosed only to the professionals providing that treatment. So one of those exceptions would be most likely school psychiatrists. If they don't share it with anybody, don't share it with teachers, it's not done for an IEP or any other treatment plan or educational plan, but it's only internal, that would not go forward. Okay. And it would be an exception. Next slide, please. Okay. Again, personally identifiable information, and that's one of those terms of art. Includes, but not limited to, the student's name, the name of the student's parents or other family members, personal identifiers, such as social security number, student number, or biometric record. So if they've done fingerprints or any kind of DNA sample, that would be included. Other indirect identifiers would be, date of birth, place of birth, mother's maiden name, and could be if they're adopted or foster or step parents, that could be other identifiable information as well. Next slide, please. Other information that alone or in combination with is linked or linkable to a specific student that would allow a reasonable person in the school community who does not have personal knowledge of the relevant circumstances to identify the student with reasonable certainty is personal identifiable information. So this is one of those, yes, it's a big word salad. So if you got something that says John Smith or Jane Smith wears a red scarf all the time and may have a tattoo that indicates their mom or a favorite race car, and people in the community may know about it. That's personally identifiable information. Okay. Information requested by a person who the educational agency or the institution reasonably believes knows the identity of that student to whom the educational record relates is also personal information. So that's a person's like, we're looking for something, as you know, and this is what we're looking for because we believe this person is the person. So that definition comes within that definition. Next slide, please. So let's talk about under what circumstances, prior consent is required to disclose this information. Except for specific exceptions, a parent or eligible student shall provide a signed and dated written consent before a school may disclose educational records, okay? And as most consents, let's make sure, and we go back to what are the records that we want disclosed? What's the purpose for the disclosure? And identify, the party or the class of parties to whom this disclosure may be made. An example, and I'm going to use Judge Jackson's disclaimer again, this is not legal advice, but in your consent form, you may want to put, we'd like to have all educational records as it relates to this child for purposes of designing a treatment plan. And going forward, it's going to our treatment team and it's going to be kept there. Now, you may be looking for grades. You may be looking for if there's a learning disability that could be addressed. Because if you're sending a child to a treatment program and they're dyslexic, or if their reading level is at third grade and they are a teenager, okay, um, the program needs to be crafted so that person will be able to learn. Because if you don't do that, then you're basically spinning in your wheels, because any kind of information that you may have given to them, they will not be able to understand. One of the other things which I'm going to touch on here briefly, which is not in this presentation, is like when you are doing an intake and bringing people in, it's important that you gather these records, but you may also want to find out about their dental records. You may also want to find out about their vision records, their hearing records. All right, and find out if that's been done through the institution, because it may have, if there's been some problems in school, that you can piggyback off of to be able to craft your program. Because if the person cannot see the board, that may be the reason why they're being acting up in class, which is maybe the reason why they may have experimented or used substances, because they feel they're not doing well in school, and that's just a possibility. They may not be able to hear. They may be overactive. You don't know. So those are the types of things that you may want to look at going forward. Next slide, please. Again, exceptions. Uh, wh- what conditions? Okay. What conditions is prior consent not required to disclose the information? So I don't need to have this, but it relates to K-12 schools and school districts, to school officials with legitimate educational interests, defined in the school's annual notification, and they have to send one out to schools in which student seeks or intends to enroll. So if you're trying to send a uh, child to a program that has a school involved with it, uh, they may need to get that information going forward, but it's always safe to get the consent. Uh, Federal and state and local educational authorities conducting an audit and evaluation and enforcement of educational programs. Well, that goes without saying that they like to know where their money or what's happening with their programs going forward. Next slide, please. Okay. Some more disclosures, exceptions. Organizations conducting studies on behalf of the school, to parents of a dependent student. All right. To comply with a judicial order subpoena, reasonable efforts to notify in conjunction with a health or safety emergency. And a lot of that may have come under that one is the CARES or the pandemic exception, to be able to get information going forward if you have someone in your program. But I would highly note that as the reason why you're requesting it. Directional uh, directory information and to state and local officials in conjunction with serving the student under a juvenile justice system. And make sure you check the state law, all right, because that would be important, or tribal law if you're going forward. If the tribe runs their own school system. Next slide, please. Okay. So this takes us to our last section where we talk about ethics. Okay. Throughout all of this, this is a principle that governs how we work individually and how we work as a group, how we make decisions and how we respond properly in difficult decisions. And so we have ethical principles um, that we reduce the ability to lose our job, face criminal charges, and the liability for unsuitable behavior. Typically in a wellness court, we're going to probably deal with lots of codes of conduct going forward. The model code of conduct for court employees, which mirrors a lot of the judicial code of conduct, and then code of conduct for probation officers. All right, because we deal with a lot of probation officers. Um, and needless to say, the ethics for professionals that we deal with on the outside, such as treatment providers going forward. And I didn't include that in this particular slide. We didn't, excuse us. Next slide, please. Understanding that ethical behavior requires more than just the familiarity of your profession's code of ethics, okay? Um, it's nice that I can read the canons, but I have to be able to apply the canons. And the canons are specific to the judicial field. Counselors also need to develop, a personal ethical sense that involves reflection, insight, and ensuring the best possible service delivery to their clients. Because this is definitely about how do we get our clients better, and we do what's in the best interest of our clients. Next slide, please. Okay, and so when we talk about canons, one, you got to deal with it. Judge must uphold the integrity and independence of the judiciary. The final decision must remain with the judge, and we need to be mindful of ex parte communications. And so what typically happens in this particular matter, and we apply it to juvenile healing and wellness courts or healing and wellness courts, we have teams that meet to discuss the progress of the individual, make recommendations, talk about sanctions, talk about incentives. And then there's a big question as to whether a judge can participate in those teams because of an ex parte communication, because the participant is not there at those team meetings. And how does the judge receive that information going forward? Some judges refuse to go to team meetings, and will just take the reports and the recommendations from the team when they actually have a session with their court, and they deal with the progress or recommendations for each individual client. Next section, please. Next slide. Needless to say, Canon 2 that we have to deal by. Judges should avoid impropriety of all the judge's activities. Impartiality is not disengaged, and references not appropriate. Okay. So in this particular area, and I'm going to take the last one first. If you have a person that graduated from your or is in your program and say, I want to go get a job, can I use you as a reference judge? We have a problem with that. Okay. And that should be explained to the participant that I really can't write you a letter of recommendation, but the team can talk to potential employers about hiring our people going forward because of the fact that they're in the program. Next one, please. Okay. Canon 3, we're going to perform the duties of our office impartially and diligently, keep decorum in the courtroom, decorum outside of the courtroom. So if anyone ever sees me jumping rope outside of the courtroom, that would definitely not be decorum. However, I will do that because it's being part of the community. Don't use non-public information, okay, outside of your job. It's like what I like to tell people in my court is that we keep all the tribal secrets there. Anytime someone gets in trouble, it's there. And I don't want to hear about it on Facebook. I don't want to hear someone tell me they saw it on Facebook or as someone would say, gossip book going forward. So we need to make sure that stuff that happens stays confidential with what we're doing, okay? Whether it's our practice on the bench or practice within our healing and wellness court. Next canon, please, or next slide. Okay, especially in tribal settings, I think this is important that we participate in cultural and historical activities. activities that deal with the administrative injustice. Now, be cognizant that don't use your name to go out there and say, I'm raising money about for incentives for our wellness court, because that would give the impression that you may be favorable to somebody if they come before you because they introduced money to you or gave money to your court. So that's that one of those, how do you go get solicitations? And you may want to have the team do it and not have the judge do it, and make sure that people understand that the judge is not sanctioning this, but we want to go forward to make sure that our participants have some incentives going forward. One of the things that may be good, and then we're going to go to questions and comments because we're running out of time, is to look at your cultural and traditions and histories and try to have a lot of those as your incentives going forward. So at this point, we've concluded our presentation. So does anyone have any questions or comments? And I'm going to hand it back over to Anna, and I'm going to thank Judge Jackson for allowing me to sit on her coattails.
Thank you, Judge King. Thank you, everyone. I appreciate the time. Anna?
While we wait to see if we have some questions that are submitted, I'll invite everyone in the group to submit via the chat or the Q&A. If you have comments, use the chat feature. If you have questions, you can submit those via the Q&A. I just want to thank Judge King and Judge Jackson again for sharing today, just their experience and knowledge on these topics, and then more specifically, the information pertaining to working with juveniles, because I know many of the courts that have been in operation have been serving adults. And so it's, to me, that more linear ability to work directly with an adult and get those consents. But in the juvenile healing to wellness court, you have that added layer of working with parents, especially if you're in a state that requires you, or a tribal community that requires you to engage with parents and get consent prior to working with that youth. And so I know that that's something that has come up as we worked with the juvenile healing to wellness courts that are being implemented. So I appreciate that conversation and then the discussion around FERPA. So I'm going to go ahead and check our Q&A. Okay, so we have a question. Is there a model release of information for a tribal juvenile healing to wellness court that can be shared? Thank you very much. I will just share from the Tribal Youth Resource Center. We have some resources and materials that we can share. Like we shared at the beginning of the session, it is so important for you to look at local guidance and work with your local legal counsel. And so we do provide some templates that you can look at and see if that will work for you, but it should be adapted specifically to your community's policies, procedures, and laws, and in consideration of the laws that we talked about today. So if you reach out to us, we can send you some examples. But again, the advice would be that, we can't provide a legal form specific to your community, but we can provide resources that you can look at and review. And then I'll let Judge King and Judge Jackson speak to that as well.
I agree. Always look for models elsewhere. Don't try to reinvent the wheel, but make sure the wheel fits your car, is how I'll say that. So don't just adopt something and take out a name and put your name in there, because what was written might be applicable to that court based on not only federal law, but also applicable state or tribal law. So, you can not reinvent the wheel, but, make sure that wheel fits your car.
I would agree wholeheartedly.
We have a few comments in the chat box. Mentioned to use cultural activities as incentives. How does that look in your healing to wellness court?
Well, may I take that since I mentioned that? There could be learning how to build a canoe, okay? And then after you learn how to build a canoe, taking it on a trip. Or, drumming, building drums. building gourds, doing those types of things could be used as incentives as opposed to, um, saying, give me movie tickets or give me bus passes. Okay. Um, and I think that creates a stronger tie than if you send someone to a movie theater and give them popcorn, as opposed to something that they can figure out where my strengths are going forward.
And I can give another example, is if you have a fair and maybe you have a restriction on, when someone can be out in the community. They may have an early curfew, or they may be on house arrest. Maybe they're doing remarkably well, and there's a part of the fair or cultural activity or gathering that might be relevant to their healing, and maybe you allow them to go as an incentive, or maybe they're escorted or something along those lines. So that might be something that could be used as an incentive based on the individual's progress on their treatment plan. Also keep in mind that some of your sanctions can turn into incentives that are culturally appropriate, and sometimes these happen just naturally on their own, and they're not planned that way. When at Fort McDowell we had a juvenile that was just completely disrespectful, and one of the things that we sanctioned him to, with permission of an elder, is to help that elder with his yard work and cleaning out the shed. Well, over a period of time, that became something the kid liked to do. So obviously we couldn't use it as a sanction anymore. And it became an incentive that you can go help elder so-and-so, clean out the shed or with his yard work. And then it turned into a mentor-mentee relationship, where that juvenile was then taught about cultural history and about his family and the family's um, history of basket making, and it just turned out to be a really positive relationship. So those are things that, one, think out of the box, two, they could turn into something different, and keep in mind that I'm sure that child got more out of that relationship with the elder than he would have received, as Judge King said, going to the movies. So keep that in mind as well. But that doesn't mean that you can't utilize incentives like going to the movies. It's just figuring out what works for that child, or that individual participant, based on where they are in your program.
Thank you. We have a couple of really good comments, but I know we're coming to the end of our time. We did have a comment about, are we aware of any ethical violations that have been appealed through our tribal court judicial system, and the outcomes of those cases? That might be one we have to follow up on. A more specific question to the consent procedure in and of itself is a group consent, so one that lists the entire team as opposed to individual releases of information for every team member / organization. So a couple of comments there. I'll let you quickly address if you have time to do that.
I would do a release of information for the entire team and for the program, as opposed to individual members. And that should be in your assessment, your initiation, or initial packet that you give out going forward, so they understand that a member of the team would be making those inquiries. But that's also an orientation for members of the team to understand their responsibility of how they get information and how they divulge information going forward.
I agree with that. And as far as ethical violations, for judges, usually ethical violations are handled by the governing board that monitors that type of behavior. So in the case of judges, Judge King and I are governed by the Arizona Supreme Court Code of Judicial Conduct, or Judicial Commission, and behavioral health is monitored by that agency. So those complaints normally go through there. We wouldn't necessarily have that information unless you went through and did a search. I am aware of the one treatment provider that was sanctioned for not releasing information, but that was not necessarily an ethical issue, but more of a legal issue. And so I'm sure that there are some individuals that have been sanctioned. They would be sanctioned not by the court unless there was a contempt issue, but they would more likely be sanctioned by their commission that governs their profession. So Judge King, feel free to add.
That would be correct. There has been some ethics opinions that have been issued as it relates to state drug courts and the ability of judges to participate that have been adopted by tribes in if they adopt such rules. But there are some, and I believe that NADCP has some of those opinions because they've talked about the work of judges and how they can work on wellness courts.
And added to that, just really quickly, I want to mention that in the model rules, the ABA model rules, as well as some of the state courts have adopted a specific provision that allows or gives an exemption for judges to participate in the treatment court model, and exempts them from a specific sanction for a violation of a canon for that purpose. Thank you.
Thank you. So I want to thank both of you again, and there's contact information there on the screen, and it will be in the materials so that you can outreach to Judge King or Judge Jackson following the presentation. And I just want to, my personal comment is a thank you to both of you, and just that this is building towards a whole environment of respect and reducing that stigmatization for participants in the wellness court. And so I know that it does go very deep. There's a lot of details involved in getting participants into the court, but this work is worth it. And so we thank all of you today as attendees for all the work that you're doing and the coordination to provide services to the members of your community. So we would invite you to fill out the evaluation for today. There is a link in the chat box. We thank you for your feedback. It does help us with future presentations and future training opportunities. And if you're interested in more training on this topic, which I know that there is going to be great interest, I think, in the FERPA discussion, look forward to continued conversations about everything that we discussed today. If there's other topics that you're interested in, please let us know on that evaluation form. I wanted to let you know that there are 2 additional workshops that will be held later today. In the family track, there is a workshop B3, Family Treatment Court Best Practice Standards Through the Eyes of Healing to Wellness Courts, practice applications of the standards presented by Dr. Kristen Frescon, Will Blakely, the Honorable Carrie Garrow, and the Honorable Stacy Four-Star. In the general track, we will have workshop B4, Promising Practices in Tribal Community Policing, Perspectives from Experienced Officers in the Field, presented by Francis Bradley, Maria Galvin, and Jordan Martinson. To join those workshops, please go back into the virtual lobby, enter the enhancement training door to join B3 or B4. Please note that these workshops will start in 1 hour, so we invite you to stretch, take a break, have lunch, visit the Resource Center and the wellness spaces, and enjoy your afternoon. Thank you again for being present today. We appreciate all of you.